Just before we get started, I wanted to say that some content in this video may be upsetting for some viewers. Viewer discretion is advised. The United States has a history of change. Every day something new happens that causes us to question why, or is this the best for me? These questions have been happening every day for over 200 years. And these questions are why we have laws that tell us what we can and can't do. But what if we feel like these laws are wrong?
Cities across the United States remain in a state of high tension tonight.
For a governor and a mayor and a city council to override the will of the people.
Well, the obvious thing to do is to challenge these laws. And the best way to do that is by the judicial system. There have been many landmark cases in the judicial system that have changed our view of America. McCulloch versus Maryland, Brown versus Board of Education, Miranda versus Arizona, and Roe versus Wade are all examples. These cases all impacted America substantially, but differently. If we didn't have McCulloch versus Maryland, then maybe the states would have more power than the federal government. If we didn't have Brown versus Board of Education, then maybe segregation would still be around. If we didn't have Miranda versus Arizona, then how many people would be arrested because they didn't know their Miranda rights? But what if we didn't have Roe versus Wade?
It's our position that the state may not consider strictly moral questions. It cannot find just a strictly moral justification in enacting criminal legislation. They have to find some justification, some secular justification for criminal legislation.
The woman talking in the interview you just watched is Linda Coffey. She was one of the attorneys for Norman McCorvey, otherwise known as Jane Roe. This interview was done on June 17, 1970. One day after a lawsuit was filed that challenged Texas's law banning abortions unless the mother's health was in danger. However, Texas's law wasn't exactly uncommon. By the start of the 1900s, every state had anti-abortion laws. Even still, illegal abortions were still common and people were still prosecuted for conducting or having illegal abortions, though the punishments weren't severe unless the mother passed away. If a mother were to pass away while having an abortion, the practitioner would be charged with murder. And since medical science was not as advanced as it is now, deaths weren't uncommon during abortions. So most practitioners avoided the risk altogether. Historically though, abortions weren't accepted. Whether legally or morally, people who got abortions or those who did abortions were seen as wrong or shady. Even during the rise of feminism in the late 1800s, women did not view having an abortion in a good light, though the reasoning was slightly different. Feminists of that era believed that abortions were an undesirable necessity forced on women. In a newspaper operated by Elizabeth Stanton and Susan B. Anthony, a writer wrote that simply passing an abortion law would
be only mowing the top of the noxious weed while the root remains. No matter what the motive, love of ease or a desire to save from suffering the unborn innocent, the woman is awfully guilty who commits the deed, but it will burden her conscience in life, and it will burden her soul in death. But oh, thrice guilty is he who drove her to the desperation which impelled her to the crime.
However, people's views slowly began to change. After 1900, some states allowed for abortions in the case of rape, incest, or to protect the mother's health. And from there, abortions only grew more available and more accepted. The increase in availability was also helped by the creation of the American Birth Control League in 1921 and the Planned Parenthood Federation of America in 1942.
In Dallas, Texas, 3 shots were fired at President Kennedy's motorcade in downtown Dallas.
As the 1960s rolled around, so did even more change. One of the earliest examples of this change was the case of Sherry Finkbein. Sherry was the host of a children's television show. She was also the mother of 4 healthy children, but as she became pregnant with her 5th child, the doctors wondered that her unborn child may have severe deformities. Unfortunately, the reason Sherry's case became so popular was because a writer for a newspaper revealed her identity, even though she wished to remain anonymous. Still, Sherry traveled to Sweden to obtain a legal abortion, but people were upset that she had to travel overseas to get an abortion, and that was not something many women wanting abortions could do. Finally, real change started to occur in 1967 when Colorado became the first state to decriminalize abortions in the case of rape, incest, or when the mother's health was in question. In 1970, California, Oregon, and North Carolina all passed similar laws. Then, in the same year, Hawaii became the first state to legalize abortions on the request of the woman. Also in 1970, New York repealed its more stricter abortion laws, and Alaska and Wyoming did the same. In Washington specifically, the repeal was done by a vote of the people. By 1972, 13 states allowed abortion in the case of rape, incest, or when the mother's health was in question. Mississippi only allowed abortions in the case of rape or incest, and Alabama and Massachusetts allowed abortion in the case of the woman's health being endangered. Every other state still marked abortion as illegal. But this all changed when Roe v. Wade hit the courts.
Jane Roe means so many different things to different people.
To different people.
What does Norma McCorvey mean to you?
It's my mom.
Before I talk about Roe v. Wade, the case, I want to talk about Roe and Wade as people. First, Jane Roe. Jane Roe is actually a pseudonym for Norma Leigh Nelson McCorvey. Norma was born in Simmonsport, Louisiana in late 1947. Her family then moved to Houston in her later childhood. However, Norma's father left the family shortly thereafter. Norma was raised by her mother, who was a violent alcoholic, and Norma got involved in crime. When Norma was 10, she robbed the gas station cash register and ran away to Oklahoma City with a friend. She then convinced the hotel manager to let the two rent a room, and a maid walked in on Norma and her friend making out. Norma was then arrested and made a ward of the state. Norma spent her early teenage years in a Catholic boarding school, which she said was the happiest time of her childhood. Though this happiness was dampened when she returned home, where she was allegedly raped multiple times by her cousin. At the age of 16, Norma married, but left the man after he allegedly assaulted her. Norma gave birth to her first child, Melissa, in 1965. However, after Melissa's birth, Norma developed a severe drinking and drug problem. Shortly after this, Norma began to identify as lesbian. Now, this next part is muddy, but Norma claims that her mother tricked her into signing adoption paperwork to give Melissa to her mother. Obviously, her mother claims that Norma willingly signed the paperwork, but in any case, Melissa was adopted by her grandmother. Then, in the next year, Norma gave birth again, and this baby was given up for adoption. Now, we finally reached Norma's side of Roe v. Wade. When she was 21, Norma became pregnant again. Her friends said that Norma should claim that she was raped by a group of black men to hopefully obtain a legal abortion. However, there was no evidence for this claim, and Norma's attempt was not successful. Norma then attempted to receive an illegal abortion, but the clinic she went to was shut down by authorities. Finally, Norma was introduced to Linda Coffey and Sarah Weddington. I will get to the process of the case later on, since that's the main reason I'm making this video, but the case took too long and Norma still gave birth to her third child, who was also put up for adoption. 20 years after the Roe v. Wade case, Norma published a book called I Am Roe. At a book signing event, Norma met a minister and director of an anti-abortion organization. This meeting caused Norma to actually join the anti-abortion organization and convert to Catholicism. She lived the rest of her life as an anti-abortion activist until she passed away on February 18, 2017 at the age of 69.
Well, since I've been this attorney, I've tried 24 death penalty cases, which we asked the death penalty.
And how many death verdicts did you get?
23.
On the other side of the Roe v. Wade case, there's the defendant, Henry Wade. Henry was one of 11 children and was born in 1914. Along with 5 of his brothers, he entered the legal profession. Henry worked for the FBI under J. Edgar Hoover in 1939 and was part of the invasions of the Philippines and Okinawa during World War II. After the war, Henry joined the Dallas County District Attorney's Office, which he was a part of for 36 years until his retirement. In the interview I showed before, Henry was asked about a case in which he was pursuing the death penalty. The case that was being discussed was the prosecution of Jack Ruby, the killer of Lee Harvey Oswald. Actually, Wade was supposed to be the prosecutor for Lee Harvey Oswald, but had to move suspect when Ruby killed Oswald. Of course, Wade didn't directly proceed over the courtroom, but was closely involved. Just a couple years later, in the Roe v. Wade case appeared on Wade's table. Again, I will talk about the case in a second, but it's crazy that Wade was a part of two historic cases just a few years apart. Despite Wade's loss in Roe v. Wade, he was not blamed and his career didn't suffer. Wade served as an attorney for 14 more years and then retired. In 2000, the Texas Lawyer magazine named Wade as one of the 102 most influential lawyers of the 1900s. Henry Wade passed away on March 1st, 2001 at the age of 86.
That decision is personal, not only for the people of the state of New York, but for each and every member of this legislature. And I'm not going to have 149 members of this legislature tell my wife what her decision should be in case she desires an abortion.
Now that we've talked about the plaintiff and the defendant, we can talk about the case. Roe v. Wade started off as a lower court case that eventually made its way all the way up to the Supreme Court. However, the two main orchestrators of the case started their quest to make abortion legal before Roe v. Wade. These two people were Sarah Weddington and Linda Coffey. Their first plaintiffs were a married couple. The suit would state that abortions were medically necessary for the married woman. The woman had a neurochemical disorder and doctors considered it medically necessary for her to not give birth. However, the couple didn't want to abstain from sex and contraceptives may fail. The married couple would have been an excellent plaintiff if the woman was actually pregnant, but since the woman was not pregnant, the attorneys were convinced that they needed to find a pregnant woman who wanted an abortion and would be willing to be a plaintiff. After being unable to find someone who fits their criteria, the two attorneys stumbled upon Norma McCorvey. Norma said that she didn't know if abortion should be legal. However, Weddington allegedly told Norma, "It's just a piece of tissue. You just missed your period." This statement convinced Norma that abortion should be legal. Norma also gave permission to Weddington and Coffey to represent her in court under the impression that she would eventually be able to get a legal abortion. Unfortunately, Norma gave birth to her third child on June 2, 1970. Shortly afterward, Weddington and Coffey filed Roe v. Wade in the U.S. District Court for the Northern District of Texas on behalf of Norma, who was given the pseudonym Jane Rowe. The two attorneys also filed Doe's v. Wade for the married couple. The lawsuit was heard by a 3-panel judge, with 2 judges being district court judges and the last judge being an appellate judge. The 2 district judges were William McLaughlin Taylor Jr. and Sarah T. Hughes. Hughes was thought to be sympathetic to the attorney's cause. The appellate judge was Irving Loeb Goldberg of the U.S. Court of Appeals for the 5th Circuit. On June 17, 1970, the judges unanimously ruled in Norma's favor that Texas law was unconstitutional. The 3 judges noted that Texas's law went against the 9th Amendment. Both sides appealed the ruling, so the decision was left to the Supreme Court. However, the case was delayed so that the Supreme Court could handle other rulings, specifically on judicial jurisdiction. Also, once this case reached the Supreme Court, it should have been named Wade v. Roe, but the name stayed as Roe v. Wade for whatever reason. Finally, the Supreme Court was prepared to decide on Roe v. Wade. The first course of action was to decide which court should have jurisdiction over the case, though no one told Weddington about this decision. So Weddington spent about 30 minutes discussing jurisdiction and not constitutional legality. After Weddington's opening argument, attorney J. Floyd, who was representing Henry Wade, made his opening statement.
Mr. Chief Justice, and may it please the court, it's an old joke, but when a man argues against 2 beautiful ladies like this, they are going to have the last word.
This joke, obviously, didn't sit well with most people involved. It's also notable that Norma was not present during the hearing. In fact, Weddington did not speak with Norma until 4 months after Roe v. Wade was decided. Roe v. Wade was argued and re-argued all the way up till a decision was made. Through the arguments and the recesses, judges spent time researching abortion and abortion history in the United States. And finally, on January 22nd, 1973, the Supreme Court ruled 7-2 in favor of Norma McCorvey, otherwise known as Jane Roe. The Supreme Court stated that women in the United States had a fundamental right to choose whether or not to have an abortion without excessive government regulation.
For the women women who took to the streets all over America today. This was about stopping the reversal of the abortion laws their mothers and grandmothers had fought for.
Now, if that was all there was to say, this video would end right here.
This decision must not stand!
But it doesn't end here.
My body, my choice!
The decision that came from Roe versus Wade didn't end the protesting. The decision that came from Roe versus Wade didn't end the arguing. Roe versus Wade made it unconstitutional to make abortion illegal, but there's more to having an abortion. For years, the argument then transitioned to how long can a woman wait to have an abortion. There is a point in a pregnancy where a fetus can survive, even before the 9-month period is over. Especially as medical science advances, we're becoming better and better at taking care of babies born before they can survive on their own. The survival rate is different for everyone, but the earliest a baby can currently be born is about 22 weeks. The survival chance at 22 weeks is 0 to 10%, but at 24 weeks the survival rate goes up to 40 to 70%. That is why the age of viability is considered 24 weeks. So when should a woman be able to receive an abortion? Well, that's the million-dollar question. In the United States, most states allow abortions 22 weeks or 24 weeks after becoming pregnant. There are also a number of states that allow abortions until the baby becomes viable, which normally occurs at 24 weeks. However, there is one state that is different, and it's the state where this whole story began: Texas. In Texas, a woman cannot have an abortion after 6 weeks of gestation, or until a fetal heartbeat is seen. I will say though that in every state, an abortion can still happen if the mother's life is in danger. Ever since Roe versus Wade, people have been limiting abortions. Not only has the period to get an abortion been shrinking, but there have also been pieces of legislation like the Hyde Amendment. The Hyde Amendment was passed in 1977 and its job is to stop people from using federal funds to pay for an abortion, except for the cases to save a mother's life, incest, or rape. However, not every state has followed the Hyde Amendment. 16 states have some type of fund to help pay for abortions in some capacity. But this isn't all. Over the years, access to abortion has been limited, but this isn't everything we've done.
Where do privacy and personal freedom begin, and where do they end? Questions that have framed an enduring divide in modern America. One many thought was settled nearly 50 years ago when the Supreme Court affirmed a constitutional right to an abortion. Today, the court answered that question again, this time on a 5-4 vote, taking away what was regarded as a fundamental right.
On June 24, 2022, the Supreme Court overturned the near 50-year-old decision. In the case Dobbs v. Jackson Women's Health Organization, the Supreme Court said that abortion was not deeply rooted in this nation's history or tradition. Also, abortion was not considered a right when the Due Process Clause was ratified in 1868. The official wording of the Due Process Clause, specifically in the 14th Amendment, is, "Nor shall any state deprive any person of life, liberty, or property without due process of law." This second decision has been heavily criticized and praised by pro-abortion and anti-abortion factions, respectively. Most notably, though, the decision has been criticized by law historians because the argument that abortion is not rooted in American tradition does not apply to other rights that we consider as rights now. Examples of this contradiction are contraceptives, interracial marriage, and same-sex marriage. Also, the Due Process Clause was not factored into the decisions that allowed contraceptives, interracial marriage, and same-sex marriage. And that's where we stand now. As for the next step, a lot of states have already issued bans on abortion, but it's unknown how many states will follow. Since everything is so new and happening so recently, finding solid information from unbiased sources is, well, difficult. Still, I doubt every state will outright ban abortions like some people think. However, there will be bans and restrictions, but I don't know how that will affect us or what might happen in the future. There's been a lot of people saying that abortion should be codified into the Constitution, which would work if there was enough political support. The problem would be gaining enough political support to pass something. But that's the problem for just about anything nowadays. If we take politics out of this problem, the people want abortion to be legal. In a CBC News/YouGov poll, 59% of people disapprove of the Supreme Court's decision. According to the same poll, 52% of America thinks that the new decision is a step backward, and 31% of people say the decision was a step forward. As for which one is true, only time will tell. I do have my own thoughts on abortion, but I'm not putting them here because we don't need any more opinions. We need facts. So that's that. Actually, Not quite. So literally the day after I initially recorded everything, President Biden signed an executive order that protected abortions. However, this order doesn't go against the new Roe v. Wade decision. Overall, the executive order only affects states where abortion is still legal. I will write some of the major points here on screen, but I doubt we'll know exactly what's going on until later on. And I also have to add that there is a bunch more stuff going on daily. People are constantly trying to fight for abortion every single day, whether on the streets or in the political offices. So trying to get up-to-date details that are completely unbiased is a little bit difficult. Anyway, back to the outro. I haven't covered everything, but I feel like I've covered enough information to help people form an opinion or people make a decision on what to do. If you don't like the decision, or if you're actually on the other side of the fence and don't feel like the decision goes far enough, there's only one thing to do. Vote. Vote for people who you feel like will support your belief. Vote and find information that's right, not information that makes you right. With that said, I hope you guys enjoyed the video. This video took forever to write because I wanted it to be as factual and unbiased as possible, but I'll catch you guys next time. Peace!